Now up to a judge to decide if a felony conviction against Owen Labrie should be set aside. The former St. Paul student was convicted of several crimes, the one felony being certain uses of computer services prohibited. And today, the prosecutors responded to the defense's request that the conviction be set aside. WMUR's Suzanne Rowntree joins us now with a look at the future of this case.
Well, the state's detailed response is 23 pages and spells out why they think this conviction should stand. Legal analyst Dave Ruoff says it's an uphill battle for the defense.
The chance of the judge actually dismissing or setting aside the verdict in this case is very, very small.
Owen Labrie was convicted of certain uses of computer services prohibited, a felony-level offense that basically says he used the internet to lure a 15-year-old into a sexual assault on the campus of the exclusive St. Paul's Prep School in Concord.
The defense has filed the motion specifically targeting the one felony conviction because they're doing everything they can to avoid having Mr. Labrie have to report for the rest of his life as a sex offender.
Legal analyst David Ruoff says the response filed by the state on Thursday makes the point that it's too late now to object to something a jury was considering as the trial wrapped up.
Under the law, the defense is required to object to jury instructions at the time that they are given. And the state's argument really is very simple, which is you didn't object when the jury was instructed on how they are to apply the law in this case. And so it's too late for you to raise it now.
Ruoff says the state goes on to say the certain uses of computer services prohibited charges doesn't differentiate between people who are acquainted and involved in a sexual assault and anonymous people prowling the internet looking for victims.
And says there was ample evidence to support the conviction. And by the way, the court should not be reading words into the statute that aren't there and that the legislature didn't put there.
Ruoff says the judge will likely hold a hearing.
I don't expect any additional documents would be filed. It's really pretty well explained in the state's objection and the motion filed by the defense.
The judge has 60 days to issue an order, but it's likely it will be made before the October 29th sentencing date. Live in the studio, Suzanne Rowntree, WMUR News 9.